Hello and welcome to One and All. My name is LAKSHAYA and I'm an intern at LEXIS and Co. I'm a third year law student at New Law College, Pune, and the topic for the day is Impact of COVID-19 on Contracts. The unanticipated coronavirus epidemic has disrupted our personal, professional, financial, and commercial life to the point that best performances are unattainable at all levels. This article will focus on the influence of COVID-19 on contract performance under Indian law. We examine whether the possibility of performance under Indian law is entirely an issue of contract drafting, and if so, can business salvage their responsibilities and save their contracts using the lines given above and from the English law. We believe that by publishing this article, businesses will be able to take a closer look at the contracts and determine whether or not their performance can be excused without liability or compelled by law. We also shed light on the difficulty of performance of contracts regulated by the commonly adopted English law and what elements of English courts or tribunals might be examined in the instance like this. COVID-19 has either made it difficult or impossible to accomplish. It has made it difficulties for some parties to fulfill their contractual obligations while rendering others utterly incapable of doing so. Section 56 of the Indian Contract Act 1872 provides for the impossibility of performing contract after it has been executed, that is ICA. Section 56 is found in Chapter 4 of the ICA, which deals with the contract performance and purports to address one type of circumstance in which contract performance is excused or dispensed with. It contains the following features. Section 56 states that an agreement to do an impossible act is itself void. A contract to do an act which turns out to be impossible after it has been made by reason or of some event which the promiser could not prevent, thus the contract becomes void. Although if the promiser makes a promise to the promisee that an impossible act is possible while knowing that the act will not be fulfilled, such promiser must make compensation to the promisee for the same promise. The majority of contracts specifically state that the contract will be stopped or terminated if certain events occur. In such instances, the contract would be terminated according to the terms of the agreement. Although in English law, these cases are treated as cases of frustration as detailed in Part B below in India. They would be dealt with under Section 32 of the Indian Contract Act, which deals with the contingent contract or similar other provisions contained in the Act. The following is the section of the Indian Contract Act. Contingent contracts to do or not to do or anything. If an uncertain future event happens, it cannot be enforced until the future event has happened. If the said future event becomes impossible, such a contract is termed as void. There may be instances where an unforeseen incident renders performance impossible just for the duration of the event, allowing a window for resuming normal contractual responsibilities once the event has ended. In such cases, the concept of force majeure comes into play. Force majeure arises from the contract in Indian law as it does in English law. The purpose of this clause is to protect the performing party from repercussions of a breach caused by unforeseen incident. As a result, it is an exception for the contract violation, the type of general terms of the contract, the circumstances that precede or follow it, and the facts of the case that will determine whether force majeure can be used to dismiss obligations for non-performance. In the event of force majeure, the party must choose whether or not to utilize the contract's force majeure clause to relieve it from the contract's performance. This is all I can cover in part 1. Part 2 is up in the next video. Please stay tuned. Thank you.